Put your hands behind.
No, look, I'll do your test. I'll do your test. I'll do your test.
Get on the ground! Roll over right now!
My name is Lieutenant Colonel Lee Roger Wolfgram, and I am a storyteller. Welcome to the bunker. Hey everyone, welcome back to the Colonel channel, and I have a video today that really caught my attention because it was a lawyer that was arrested for DWI. Of course, the lawyer, I don't know if he was a criminal defense lawyer, but you know, lawyers have general knowledge of a lot of different areas. But anyway, lawyers stopped for suspicion of a DWI, and watch what happens to this lawyer, and then we'll talk along the way. But this was one here where I thought, good. April
16th, 2019, Officer Mark Batson of the Louisville Metro Police Department pulled over 64-year-old attorney Douglas Miller for allegedly driving 76 miles per hour in a 55 mile per hour zone in Louisville, Kentucky. Officer Batson did not immediately activate his body-worn camera, so the first part of the interaction was not recorded.
Let me stop this. So this one really gets my goat. So there are policies when you come into contact with the public where there's any chance that there would be any legal relevance to it. The camera policies require the camera to be turned on. So we don't know when the cop approaches this car, he doesn't turn on the camera till he gets there. There's obviously been a discussion that occurs early. So right away, you know, like I've said before, my alert is up, there's hanky-panky afoot, and let's just see how that works out.
However, the majority of the encounter was captured on Officer Batson's body camera.
Okay. I would never do that. Okay. You have your registration or insurance? Yes. All right, sit back on. I'll be out on sobriety checks.
So he's going to be out on sobriety checks. Now, I don't know what the driving conduct was, but he's going to be out on sobriety checks, which means he's probably going to have him do the one-legged stand, the walk and turn, maybe some horizontal eye nystagmus test, all pretty much run-of-the-mill. However, I don't know what happened at that door that would allow this to change from whatever the original reason from the stop was to a DWI investigation. So that's critical information that's been decided by the officer. That's not important. But I will tell you, as a defense guy on a DWI, this is the first thing I'm looking at after driving conduct is what is happening at the window of the car on the initial encounter. Do they sound slurred? How are they acting toward the officer? Are they giving them what they're asking for? All of those things are, I would say this would have been exculpatory information, meaning it would tend to show that he is not impaired, but we don't have that beginning. But the cop thinks he's, well, all the cops thinks he's intoxicated. That's the word they use, intoxicated.
Do me a favor, go ahead and step on out for me. Okay, if you want to. You lied to me. You lied to me. Do you have anything on you I need to know about? Drugs, guns, knives, the beer bottle under your seat? No, I don't have any. All right. Step on back here. We're going to do some field sobriety checks. Right back here. Stand right there for me. I didn't know if you meant...
I passed those checks.
Okay. Walk over to the front of my car. Just stand right there for me.
So the attorney feels that he's passed the test. So now he's wondering, what are we doing now?
You ever taken one of these before?
No, like I said, I've got one in my car.
Like this one?
I know it's
Yeah.
the old Apple.
Okay, so, and you know what? I have one too, right? So you want to make sure, because if you don't drink a lot, you want to make sure you're not impaired. This attorney is trying to be responsible. He's got his own preliminary breath test or test device. And of course, those aren't necessarily calibrated to the same standards as law enforcement. But he knows that he's not impaired because I presume he took a test before he started driving. Then he just passed the field sobriety test. But this officer is going to insist that he takes a PBT as well, preliminary breath test. The reason why he's hesitating a little bit is because he's like feeling like, why? I just did everything you asked me to do. I'm not impaired. He knows he's not impaired, yet the officer insists.
Yeah, this is the new and improvement. So just going to be, take a deep breath in. You're going to hold it for just a second. But if you're an attorney, you know it's not a pass-fail test. You have shown some clues of impairment. So,
How long have you been on the force?
10 years. Are you going to do this or not?
I mean, I'll do what you want me to do.
Hey, it's your choice.
No, no.
Are you going to do this or not?
What are you going to do if I say no? You're going to arrest me.
I have no idea.
So he's just lying. Like, if you don't take the test, I don't know what I'm going to do. He knows damn right what he's going to do. If he doesn't take the test, he's going to take him into custody and he is going to give him the official test or offer him the official test at the police station. So again, the cop's just not being straight up with the public. I don't know what's going to happen.
I mean, I've already seen the bottle under your seat that you told me wasn't in there, that you were hiding when you were driving, which is tampering with physical evidence, which is a felony. Go ahead and turn around for me. Put your hands behind.
No, look, I'll do your test. I'll do your test.
So he goes right from having a discussion, the lawyer's just trying to ask some questions, to right away he gets physical on him. So this is force being used.
I'll take your test.
Get on the ground! Roll over right now!
Okay, see where his hand is? On his throat.
11:35, start me a car, one fighting. Roll over, on your stomach, now! Now! You're under arrest. Get on the ground!
He's on the ground, officer.
Put your hand behind your back right now.
I'm not struggling.
Put your hand behind your back. Put your hand behind your back. Put your hand behind your back.
You're holding my hand.
Roll on your stomach right now. Yes, at this point you are under arrest. And I told you that before. Now you got resisting.
Oh, my God.
Stay right there.
I'm not doing it. Oh, please.
11:25, start me a
Please,
seal.
tell me this is a dream. Tell me this is a dream. Oh, you bloody my nose.
Just stay there.
I'm not going anywhere.
Boy, this cop is a tough guy. You can just see by his attitude, like he just escalates. That's all this cop knows. He just knows to escalate. So the guy's asking him a question. He's an attorney, doesn't present any danger that I can see at all. He's being compliant for the most part. He's just being inquisitive. And this guy goes big time bully on him. This guy needs to be fired. His attitude is a part of the problem. Why people are asking for police departments to be defunded. It's people like that. And I bet you the whole department's like that. We'll see.
Wriggling enough.
You got blood. You bloodied my nose. Oh, God. Oh, God. Please save me. Save me. I'm not going anywhere. You don't
I know
have to
you're
sit
not.
on me.
Yes, I do. You haven't been compliant the whole time.
Please, you're
He hasn't been compliant the whole time. Is that what you saw?
hurting me.
Stay there.
Please, you're really hurting me. Oh, God. Please, please, stop. Stop.
Quit moving.
Okay, so another guy comes, puts his knee down.
You're killing me.
He's already cuffed. He needs to go in a car. Okay.
I'm already cuffed. Oh, please.
So if he's already cuffed, Why the knee on the neck? Why didn't the other officer stand him up and put him in the car? Is this because he's delaying until another officer comes so he can act like this was a big deal and that's why he needed assistance? Because I think if the guy's in cuffs, he should already be in the back of the squad car if that's where he's headed.
Okay. Just relax.
God almighty!
Do not move until I tell you to.
Okay, I'm not. Oh my God.
You don't have a bad seat, do you?
Can I stand up?
Nope. Just sit tight, man. Quit moving. Don't need to be checked out. Quit moving.
It hurts.
He just needs to go in a car. What's that? He needs to go in somebody's car. All right, roll over to my side. There you go. Put your feet under and you can sit up.
Officer Batson conducts sobriety tests on Mr. Miller and then asks him to submit to a breathalyzer test. When Mr. Miller does not immediately agree to take the test, Officer Batson orders him to turn around and put his hands behind his back. Mr. Miller tells him that he will take the breathalyzer, and Officer Batson grabs him by his shirt, throws him against the car, and then takes him to the ground. Officer Batson grabs and squeezes Mr. Miller's throat while he radios for backup, claiming that Mr. Miller is fighting him. A tow truck driver then arrives on the scene and assists Officer Batson in handcuffing Mr. Miller. Despite the fact that body camera footage shows no signs of resistance by Mr. Miller, Officer Batson pushes Mr. Miller onto his stomach and presses his forearm into his neck for nearly a minute until Officer Troy Best arrives and drops his knee onto Mr. Miller's neck. The officers continued to hold Mr. Miller down by using their hands and knees to press his neck for another minute. We will discuss the lawfulness of the force used later in this episode, but first, let's take a look at how Officer Batson and his supervisor at the Louisville Metro Police Department characterized his use of force against Mr. Miller. In the DUI investigative field notes completed by Officer Batson regarding Mr. Miller's arrest, Officer Batson wrote, quote, "When officer grabbed the offender's right wrist to place him under arrest, the offender pulled his arm away and began to turn towards his car.
Did you see that? I didn't see that.
Officer grabbed the offender's shirt and led him to the side of the patrol car. Offender again pulled and attempted to spin away from the officer.
I didn't see that. Did you?
Grabbed offender and performed a leg sweep to take the offender to the ground. He continued, quote, "Once on the ground, the offender continued to try and get away and would
Did you see him try to get away?
not give officer his hands. VIU 12, referring to the tow truck driver, was on scene and came to assist. An offender continued to resist being placed under arrest. Officer conducted both closed and empty open hand strikes, as well as a pressure point technique to gain compliance. Officer and VIU 12 were finally able to get the offender onto his stomach and his hands behind his back to effect the arrest."
Finally. So see, here's the thing. So they write this stuff, right? And if you're not looking at the cameras, this seems like this could be the case, right? But when you look at the cameras, that's why I'm so much a fan of body-worn cameras, because it stops the bullshit, right? So this report doesn't match what actually happened. And that is one of the reasons why I have become interested in doing these videos, is to point this out. So there are good cops and bad cops. This is a bad cop. He will perjure himself on the reports. And it's part of a department-wide problem.
Once placed in handcuffs, offender still continued trying to get up. Notably, the report omitted all uses of chokehold and neck restraints, while admitting to closed and empty open hand strikes and a so-called pressure point technique. Additionally, Officer Batson's superior, Sergeant Matthew Keller, also completed a use of force report regarding the incident. Sergeant Keller's report echoed Officer Batson's account, describing Mr. Miller as actively resisting throughout the encounter. According to the report, Mr. Miller, quote, "attempted to turn to the right and face Officer Batson, pushed away from the patrol car, and continued to," now quoting again, "struggle and attempt to roll and push himself up from the ground." Sergeant Keller claimed that Batson's right hand, quote, came to rest on the operator's collarbone throat area and held that position, quote, only long enough to call for backup on the radio and then immediately release the hold. He also noted that Officer Batson, now quoting again, utilized an empty hand strike to the operator's upper torso, head, and maintained control until backup arrived. Despite the lack of any violent or assaultive behavior by Mr. Miller, Sergeant Keller reported that the reason for using force in this encounter was, quote unquote, active aggression, which LMPD Standard Operating Procedure 9.1 on use of force defines as, quote, a threat or overt act of an assault through physical or verbal means, coupled with the present ability to carry out the threat or assault, which reasonably indicates that an assault or injury to any person is imminent. Officer.
Did you see any of that imminent stuff? Did you see any of that attempting to escape stuff?
Batson told his side of the story again on April 20th, 2020, when he was interviewed during a professional standards unit investigation into his use of force against Mr. Miller. During the interview, Officer Batson reiterated his claim that Mr. Miller resisted arrest, stating that, quote, as soon as I grabbed his arm or grabbed his wrist, he immediately pulled away from me, began walking towards his car. Yeah.
I never saw him walk 2 steps, not toward his car, nowhere. He was on the ground.
Added that he, quote, grabbed his shirt and just sort of escorted him to my car, and that Mr. Miller, quote unquote, walked willingly before once again, allegedly, quote, pushed off the car, spun away, and started walking towards his car again, prompting a leg sweep. These claims are directly contradicted by body camera footage, which shows Mr. Miller being physically forced onto the cruiser and never attempting to walk away. Batson further alleged that while on the ground, Mr. Miller was, quote, actively trying to push me off, roll away, sit up. Definitely not complying with instructions. He described using, quote unquote, pressure on his forehead and delivering strikes because Mr. Miller was, quote, trying to sit up, push me away, basically get away. Again, the footage does not support these claims as Mr. Miller shows no sign of active resistance once on the ground. Batson also denied choking Mr. Miller, claiming instead that he placed his hand on, quote, the top of his chest, and that, now quoting again, my fingers were close to his neck. When pressed, he doubled down, saying that his hand was on, quote, the top of his breastplate. Yet the footage clearly shows Batson's hand wrapped around Mr. Miller's neck.
Get on the ground! Roll over right now! 11:35, start me a car, 1 fighting. Roll over on your stomach now!
Finally, Batson claimed that Mr. Miller failed to comply with verbal orders, including a command to get on the ground, although it was issued after Miller was already down, and to, quote, give up his hands, despite both of Miller's hands being physically restrained at the time. As you can see, nearly every aspect of Batson's testimony is undermined by the video evidence. In addition to violating LMPD policy, it is likely that a court would find that Officer Batson's use of force was excessive under the Fourth Amendment to the U.S. Constitution. As we have discussed before here on ATA, the Supreme Court held in the 1989 case of Graham versus Connor that claims of excessive force in the course of an arrest are analyzed under the Fourth Amendment's so-called objective reasonableness standard, identifying 3 factors to guide this inquiry: the severity of the crime
Severity of the crime. Okay, so it's a DWI, supposedly.
whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight.
No. The second car. Ow! Oh, God, you're killing me! God almighty! Go and have a seat for me. Ow! Ow! Just make sure you keep your camera on with him.
Oh, like you did? Yeah. The camera would be real helpful because the reports are absolutely useless.
So, we're good. Just wait on EMS and we'll get him down to the book. Thank you. He's an attorney.
He's an attorney?
Yeah, my camera's on.
Yeah, my camera's on because we don't want to talk shit about attorneys with our cameras on. But that's, you see, they go, he's an attorney, he's an attorney. Watch this over and over. He's an attorney, he's an attorney. Oh, my camera's on.
Can you write a toe slip so they can get that card and get out of here? Sergeant Keller should be on his way. Okay. They're going to have to do paperwork on him. Oh, yeah. So. You have the right to remain silent. Anything you say can or will be used against you in a court of law. You have the right to consult with an attorney prior to and during any questioning. If you choose to answer any questions or make any statements, you can stop at any time. Do you understand your rights? Yes. Okay, thank you. I just Mirandized him, so we're good, whatever he says now. Beautiful, thank you. Yeah, I'm good. Okay. We got to do an error on him. Good. He's bleeding, and well, he's being charged with resisting, too, so. Good. He's an attorney, so. Oh, great. So what the hell happened to you? We ended up down there. He didn't want to go in cuffs. Is the car being towed his, or is that something else? That's his. Okay. Yep. All right, maybe we'll hang here till Keller gets here. Yeah. But yeah, we're going to have to do an error on him because he's got some cuts and everything on his face. And
Error is an incident report.
Keller's going to handle that. Closed hand strikes and all that, yeah.
According to the LMPD policy of use of force at the time, Standard Operating Procedure 9.1 reads, quote, should physical force be necessary in order to gain control of a situation, an officer shall use only that force which is reasonable to gain control of the subject. Once a person is restrained or under control, the use of force is restricted to that which is reasonable to maintain control. Good.
Why is that? Because someone is in handcuffs at that point. Are you serious? Like, the threat has been completely removed as soon as they're in cuffs. So all of this stuff is excessive. It's unnecessary. The level of the crime, just the danger to anybody at all of that stuff. But the sergeant's going to go have a second look at this. Good, good.
Judgment is extremely important in deciding which tactics to use and how much force to apply. The policy continues, quote, choking techniques, even if applied appropriately, may cause a risk of death or serious physical injury because they may restrict the flow of blood or oxygen to a person's brain. Choking techniques are not an approved force option and are prohibited, except in a situation where the use of deadly force would be allowed. Use of deadly force is only authorized, quote, in defense of oneself or another when the officer reasonably believes, based on the facts and circumstances, that the person against whom the force is used poses an immediate threat of death or serious injury to the officer or to another person.
So now this is the sergeant that's going to come because they have to do an incident report.
You okay? He's being charged with resisting, closed hand strikes to the head. He's got some cuts on his face. Yeah. He's an attorney. Oh, is he? Yeah, he says he is anyway. I don't know him. Yeah. But anyway, I stopped him for speeding. Okay. He's hiding a beer bottle under the seat when I get...
This is an important part. He stopped him for speeding. Right? That's when I talked at the beginning about what occurred at the door that changed it from a speeding ticket to a DWI investigation.
Out there, for some unknown reason, just bone dry. He said he'd been drinking, did SFSTs, started playing games on the PVT. You know, I'm like, finally just, okay, forget about it, you're under arrest. Go to cuffing, he pulls away. Take him to the ground, and he's still just trying to not give me his hands, get up, stand up, roll over, you know, so. A couple, take a knee to the body and a couple strikes to the head. But I think that's came from falling to the ground. Yeah, falling on the ground. Yeah. All right, well, I'll get pictures of him, get pictures of you before it gets dark. I might snap a picture of the car. All right. I'll do the car first, I'll work my way back just in case they take off with the car.
Oh, convenient. His injuries are due to the fall to the ground from the foot sweep, incidentally. Oh, the poor officer.
Let me do your hands. All right, the canine have to help you get him cuffed. All right, gotcha. Yeah, you help me. Did you really? Yeah, he came and sat on him and got my cuffs. Really? I need to get his information then. Thanks. We get him out and get him pictures. What's that? And then get him out and get pictures of him. Hey, would you like to go to the hospital or not?
I don't know. I'm an attorney. I'm not going anywhere.
Well, you should have got handcuffed the right way then.
Just that attitude, you can see it. So the sergeant's got the same attitude. This guy's just a piece of crap, and he's a drunk, and he deserves what he gets, and he should just do whatever the cops say, I think is what he's translated quickly.
You should have got with the program and got a handcuff the right way then, if you're not going anywhere.
Even if it was a violation of your constitutional rights, even if excessive force was being used, even if there wasn't even reasonable suspicion that you were impaired.
You already resisted, so you weren't here.
Right. He wasn't there, but he knows he knows. See, the cops have got to come back for everything you say because they've been through violating people's rights many, many times. They've got the comebacks. Watch.
No, but I trust my officer. Especially when you're intoxicated and he's not. Have you ever been arrested? No. Have you ever been in handcuffs? No. Okay, well, that's how they feel. Okay? It's not killing you.
In other words, tough shit. That's just how they feel.
We're going to watch it. Well, you're intoxicated.
He's intoxicated. Now there's going to be this debate about what is intoxicated, what is not intoxicated.
Huh? Want to bet? So you're not intoxicated? You haven't had anything to drink? That's what you're saying? I didn't say I wasn't going to have something to drink. Okay, well, I didn't say you were drunk. I said you're intoxicated. No. I can tell you are. I smell it.
Oh, this cop is super cop. He can smell a DWI. Did you know that? He can smell a DWI. I don't even think you need any other testing, actually. If we just have him train all the other cops, you won't need any of that other stuff. Just sniff it out, charge him.
Let's see. So you haven't had anything to drink? Say that. Okay. You said you weren't under the influence. One drink is under the influence. Really? What is it written at? You're a lawyer. You tell me. I know what the law is. Oh, you're okay. You feel a little better now? Yeah. All right, good. Now, would you like to go to the hospital or not? I don't think I need to go to the hospital. You don't think you need to go to the hospital? No. Okay. All right, hang tight. Hang tight. All right, turn and face the police car, please. Thank you. All right, so other than your face, do you have any other complaints of pain? Just my wrist. The wrist from the handcuffs or the wrist from what happened?
Sergeant Keller filed a use of force report on May 1st, 2019. Sergeant Keller concluded that Officer Batson's use of force was justified, writing that, quote, "In my opinion, Officer Batson was justified in his action due to the need to gain control of the intoxicated operator quickly."
Do you see that language? To gain control of the intoxicated operator. So if you're just reading those reports, they all make sense. Did anybody actually look, like Sergeant, did you look at the footage? Because guess what? It doesn't match the report. So I'm kind of suspicious of how well this investigation, it seems like a whitewash.
Sergeant Keller then forwarded the report to Lieutenant Micah Shue for approval, who wrote, quote, "I concur with Sergeant Keller's assessment. It is important that any sign of physical aggression or resistance by a person be dealt with immediately." You see this? Be dealt with immediately. With what level of force? These guys go full on deadly force if you even just ask a question. And went on to conclude that, now quoting again, "The wearable video clearly shows Mr. Miller was physically resistant to arrest, and Officer Batson's actions were necessary and appropriate. Officer Batson followed policies and procedures as well as clearly established law." On June 20th, 2019, then Chief of Police Steve Conrad ordered a professional standards investigation into the use of force against Mr. Miller. However, on November 6th, 2020, Officer Batson and Officer Best were exonerated of all suspected violations, and the complaints were dismissed without any disciplinary action being taken. On April 26th, 2021, the Department of Justice opened an investigation into the Louisville Metro Police Department in the wake of the 2020 shooting death of 26-year-old Breonna Taylor, who was fatally shot by LMPD officers during a botched late-night raid at her apartment executed under a no-knock warrant. On March 8th, 2023, the DOJ issued a report concluding that the LMPD was, quote, engaged in a pattern or practice of conduct that deprives people of their rights under the Constitution and federal law, finding that the LMPD used excessive force, including unjustified neck restraints and the unreasonable use of police dogs and tasers, conducted searches based on invalid warrants, unlawfully executed search warrants without knocking and announcing, among a litany of other allegations, including its response to allegations that LMPD officers engaged in sexual misconduct or domestic violence. Specifically, with regard to the use of force, the DOJ concluded that, quote, we found that officers routinely use force disproportionate to the threat or resistance posed. Officers use force simply because people do not immediately follow their orders, even when those people are not physically resisting officers or posing a threat to anyone.
We call that being a bully. So it's just hands-on. You're going to learn your lesson. You don't talk back. You don't do anything but what we say. Immediately.
Report also stated that, now quoting again, LMPD officers use neck restraints in circumstances where they are not justified. Neck restraints, applying pressure to the neck or throat in a way that inhibits air or blood flow, are inherently dangerous and have the potential to cause serious bodily injury or death. They are objectively unreasonable where a person is already restrained or poses no danger to others. Ultimately, the DOJ determined that, quote, our review shows that LMPD officers resort to neck restraints even against people who are not resisting, or people who have already been handcuffed or otherwise subdued. LMPD policy prohibits using neck restraints except in situations where deadly force would be allowed, but officers have repeatedly violated this prohibition without being held accountable by supervisors. In fact, in the vast majority of neck restraints that we identified in our sample, the neck restraint was not even reported as a use of force, nor analyzed by supervisors for its reasonableness. As an example of an unjustified neck restraint, the DOJ cited Mr. Miller's arrest. Their account sharply contradicted the officer's reports, stating that after Mr. Miller hesitated to take the breath test, now quoting from the report, the officer took hold of him and pushed him down onto the grass, where he appeared, quote-unquote, stunned as the officer yelled, quote, roll over. The DOJ reported that Officer Batson, quote, grabbed and squeezed the man's throat, and later, after Mr. Miller was handcuffed and not resisting, quote, pressed his forearm into the man's neck for nearly a minute, stopping only when another officer arrived and, quote, dropped his knee onto the man's neck. Despite Mr. Miller screaming, quote, you're killing me, I'm already cuffed, officers continued to apply pressure to his neck. The DOJ concluded that, quote, at no point were officers justified in using neck restraints, emphasizing that Mr. Miller posed no threat and was handcuffed for much of the encounter. They also noted the, quote, deep and ongoing trauma Mr. Miller suffered as a result. The DOJ placed blame not just on individual officers, but on LMPD's entire system for reviewing use of force incidents, calling the investigations, quote, perfunctory, and noting that supervisors, quote, rarely make efforts to manage the officers on scene. Reports often, quote-unquote, mischaracterize or omit facts that would undermine a finding of justified force, and typically lack any analysis of whether better tactics could have avoided the need for force altogether. In Mr. Miller's case, the DOJ found that Sergeant Keller, quote, not only mischaracterized the chokehold, but also failed to identify the knee to the man's neck. The follow-up administrative investigation was equally flawed. One investigator admitted he conducted a, quote, quick online search of a one-handed chokehold rather than applying LMPD's own use of force policy, and dismissed the incident because the officer's technique, quote, did not resemble either of those found when doing a search. In total, the DOJ report included 36 recommended remedial measures, including enhanced use of force policies, reporting and review procedures, the creation and delivery of new new use of force training, and enhanced force-related accountability mechanisms. On December 12, 2024, the DOJ announced that it had entered into a court-enforceable consent decree with the Louisville Metro government to resolve the issues identified in the report. The 259-page document, which was filed in the U.S. District Court for the Western District of Kentucky, set out specific policies, trainings, and programs that the LMPD was required to implement, including revisions to the department's use of force policies, training, and incident review requirements, as well as misconduct review and disciplinary procedures. LMPD also revised its use of force policy on October 1, 2024 to specifically define so-called chokehold and/or choking techniques, as well as so-called carotid vascular restraint. The policy now specifically states that, quote, officers should avoid placing weight on a person's head or back for a period of time beyond that which is reasonable to gain and/or maintain control. Additionally, officers should avoid placing weight on a person's neck for a prolonged period due to the increased risk of injury as a result of air and/or blood flow restriction. Carotid vascular restraints are a use of physical force that are prohibited under the physical force policy. Likewise, the revised policy prohibits officers from allowing a restrained individual from remaining face down, as it may cause positional asphyxia, and it should be noted that the policy still only permits the use of chokeholds and choking techniques in situations where the use of deadly force would be allowed and reasonable.
Well, there you have it. So he actually had a .06 test, so he wasn't intoxicated under the law, and now you see it. So this is, you can see how difficult this is to root out of an entire department when everybody up the chain of command all thinks that this is acceptable behavior. And but for the fact that they killed somebody and the feds looked at this, this would continue to go on. And this is the challenge facing our policing today, is it doesn't have to be this way. All of this could have been done in a much different way. And the police need to be trained to de-escalate, not escalate, because this is exactly what happens, and it fosters bully cops. I want to remind you, you can get your own video in here because we're having the video contest. It already started. Any kind of video, as long as it's shown here, there is the video talking about the contest. I encourage you. It doesn't have to be anything to do with the law. It's just entertainment for the rest of the audience. You can win $1,000. Until the next time somebody gets their rights violated, this is Wolf 6 from the Wolfgram Worldwide headquarters in downtown Minneapolis. Out here.